job.
Well, you do it and you do it well.
All right, we're good to go.
Thanks so much, Carol. Our numbers are still pretty small. Why don't we give it another minute? Ms. Kaser, what is weather like in Rochester area?
We finally have our first day of sunshine, I think, in like a week, I swear. So I don't know how warm it is, but the sun is out, so I'm happy.
Good, because we didn't want to rub it in your face if you guys were getting rain while we were getting sun. So we're enjoying that same vitamin D. I mean, just based on the numbers, Mr. Vogel, we are not, I don't think we're at quorum. If we're not, is it required that we do a kind of a roll call or?
No, Mr. Chair, I can see which members are here, so I can just informally note who's here.
It's only 3 after, so I think we should just start chatting a bit. Noting that we can't approve last meeting minutes and that we can't do anything formally, but we rarely do. So we could have a discussion, and if people join, that would be great. And if at any point, Mr. Vogel, you're noticing we're near quorum, we could do a roll call.
Certainly, Mr. Chair. In fact, we're 1 member short, so as soon as we get someone, I'll let you know.
Okay. And again, there's nothing magic about quorum really for a lot of these discussions.
So just, I have to leave at 4:45. So if I pop out, don't mind me.
Fair enough. And I appreciate that. And maybe if we're smart, we'll get everybody out by 4:45. And let's just sort of see where we go. And I'm going to say with Miss Evans, if my voice totally goes, Gina, you just got to take over. So, I'm doing my best Barry White impersonation now, but when it goes, it's all you, Gina. Will had put together some slides based on just the juvenile data. And Mr. Vogel, will you mind just sort of sharing screen and just sort of going over those? And then maybe we can, Miss Evans made some comments prior to the meeting, and maybe we'll have her make those comments again, just so we have a recording. Please, Mr. Vogel.
Certainly, Mr. Chair. This data, I got from analyzing the 3rd data set, table 3, which you should have a copy of. Just let me know if you would like me to resend it to you. And I analyzed it in that spreadsheet that I just sent you. So this is essentially that data in visual form. So table 3 is taking the 2018 and 2019 disqualification data, breaking it down by the evidentiary standard used to make the disqualification determination. The look back period that determination was for, and it then breaks that information down by race. So looking at the 2018-2019 data, this is the breakdown. Well, looking at the 2018 data, this is the breakdown of the evidentiary standards used to make disqualification determinations. So the vast majority are convictions, and for the purposes of this discussion, adjudicated delinquency is about 6% of that number, which sounds small, but that's still 700 plus individuals. And then in 2019, the total number of cases increased, but for purposes of this discussion, we're still at about 6% adjudicated delinquency, now at over 1,000 individuals. So zooming in then on these adjudications of delinquency, or rather on these uses of a adjudication of delinquency, we can see the breakdown of the look back periods that those adjudications of delinquency in 2018 and in 2019 led to. So in 2018, it's I guess it's an initial gut reaction, kind of a mixed bag. Again, as a reminder, this year's disqualifying not entered for offense is essentially an artifact of the DHS system. These numbers actually should fall in these various other categories. We just don't know which. I'll point out it's not a large percentage who are permanently barred, but it's still 90 individuals. Another quarter of these disqualifications were for 15 years in 2018, and then the numbers go down from here. In 2019, there's a much smaller artifact here. This year's disqualifying not entered for offense. And we see 12% permanent bars, 34% 15-year bars, and about the same percentage, about a third, 7-year disqualifications, or excuse me, 15-year disqualifications, not 15-year bars. Carol, would you mind letting people in from the waiting room? So then moving to a breakdown of, and I'm jumping back and forth between years, so just let me know if you want me to go to a particular slide. Looking to a breakdown of the same total number of adjudicated delinquent disqualifications by race. African-American cases involving African-American applicants are the plurality, or rather were the plurality in 2018 at 42%, which is quite disproportionate to Minnesota's population. Off the top of my head, from the 2020 census, about 12% of Minnesota was identified as African-American alone. I'll note, like, this is not unique to adjudication of delinquency. If you look at that data set 3, you'll see other evidentiary standards also involving some. Also looking disproportionate to Minnesota's general population. So I'd just like to remind the members, this is probably an instance of this downstream, of how DHS is downstream from the criminal justice system. But nonetheless, this seems like a pretty significant disparity that might be of interest to you in your discussion of adjudication of delinquency. I think Ms. Evans pointed out that we see a relatively small portion of Native American cases. That's true, but the census category for American Indian or Alaska Native alone was 1.1% in 2020. So I'll note also these categories don't quite translate to the census. These are the categories used essentially by the FBI's crime statistics, which are what DHS uses for this purpose, which aren't quite the same as census categories. They give you a rough sense, I think. Moving to 2019, we again see disproportionate racial impact, especially for African-American applicants. In this case, the plurality, the percentage increased to 46% from 42%. So that's just sort of my initial gut reaction from looking at these numbers. What conclusions you draw from that, of course, is something that takes more than just glancing at a chart, but these seem like interesting elements of these charts to me in any event. So thank you, Mr. Chair and members.
Thank you very much, Mr. Vogel. And maybe we could have just a discussion about any thoughts that people have regarding just that data. Ms. Evans, as we said, we had a discussion off record. Is there anything that you want to add before we get to Judge Kulik? And we've got you muted. There we go.
Yep, my computer blanked out. Yeah, no, just that. So I have a question though first before I make any additional comments. So I don't know if we've talked about this before, but is adjudicated delinquent, is that all charges or just the EJJ charges? That's all charges. Yes.
Right.
All.
It's a little more complicated, but I think we could say, I'll take any other people weighing in on this. Like, it would be sort of the version of a conviction in some degree in the juvenile proceeding that you're adjudicated delinquent. So, but it wouldn't be charged as an adult. That would be a conviction. That would be the change.
Okay, so this is actually a finding in the court, adjudicated.
Yes.
Okay.
And you have some cases that you see that juvenile cases come through where there ends up not being an adjudication, but the department can still do the preponderance of evidence. So you will see some juvenile preponderance of evidence cases where the underlying juvenile was not found delinquent. They did some programming, and I think within a year the court has decided that they've sort of done enough and move on. So that's why the preponderance of evidence can come in too. Does that make sense to everybody?
So it's so almost like a stay of adjudication. So it's similar to like admission.
It could be. it doesn't always have to be. I mean, there are some situations, I'm sure, where a juvenile proceeding resolves that this person didn't do it. But most, in my experience, are not like that. The admission part can be part of a proceeding too, where somebody admits but isn't convicted. Same thing with juveniles too. The ones I've seen were preponderance of evidence cases.
Yeah, I'm just trying to qualify it, like figure out where it sits in my mind in the line of evidentiary standards, right? So this is completely separate from the EJJ cases, or the EJJ cases are included in here under the permanent ones.
Well, I don't know if they'd always be permanent. I mean, you could have an EJJ case that was a 15-year disqualification. I mean, if you were, and Judge Cook, please weigh in on this. You probably have more experience than all of us.
An adjudication can happen in a juvenile matter that stays in the standard juvenile jurisdiction. There also can be an adjudication in the extended juvenile jurisdiction. Okay. I think it's a fair way to understand it, to think about entering conviction and adjudicating. It means that, that is a finding and a status given, because there are stays of adjudication sometimes for juveniles, just as there are for adults, which kind of brings me to my questions about these statistics, which are helpful, but as Mr. Vogel notes, they beg a few more questions. For instance, I want to know about racial disparities in charging. I want to know who's got diversionary programs and who doesn't, because it really varies depending on what area of the state you're in, what urban area you may or may not be in, what's there for resources. Stays of adjudication. Is there any racial disparity in who gets a stay and who does not get a stay? There's just a whole bunch. I've got more questions that nobody has answers to right now, but those come to mind. And yes, I will note, I've got a pretty high percentage of Native Americans in my county, 4.5%. But even with a statewide 1.1, you see that the juvenile adjudications are 7 times the proportion of population. So something's going on. And is it just 7 times the proportion of actual offenses committed? Or are they being charged differently? Are they being diverted differently? Are they being given stays differently? Are they being prosecuted differently? Once prosecuted, what are judges doing? So that's all I got. Lots of questions.
Yeah, that's a lot. And I think there's some question of whether or not the DHS data we're looking at is just so far downstream from some of the problems that we aren't able to fix it. But I think it's an important thing to be looking at. Ms. Austin, please.
Well, and I just was going to piggyback on that. To me, I'm wondering if some of that data is more in the court data versus, for example, DHS. I don't know. I know the courts track some of that, but I don't know. I've never tried to do a request to know how hard or how easy it is to get that data.
I think we can get some of the data, and I think we have some of the data. Probably not broken down as thoroughly as Judge Kulik had identified, but I think we can look to see if it's proportionately disproportionate, when we look at the state as a whole.
Well, because I think back to that report that was circulated about which I know is not technically for us, but it was sort of an interest of the recommendations to the changes to the predatory offender, and how the report noted our state does not track people who have to register from an offense as a juvenile. So the state has no idea how many people have to register from juvenile offenses.
And based on a bill that got put into the judiciary this year, it's my understanding that they don't track stays and downward departures and upward departures, that they don't track it like they're supposed to, because somebody put in a bill this year to mandate that they start tracking that stuff.
I think it's a good reminder too, that even if we have some disproportionate stuff upstream, we could still be looking at the disproportionate nature of the collateral consequences in terms of employment. And if you think about it, these cases involve people's employment and sometimes even being able to take care of their own family, PCA services, foster care services, and so on. So I think there are things we're not going to solve. I think the disproportionate prosecutorial issues that might exist in some counties, but we can certainly look at, how it impacts as a collateral consequence.
And we can shine a light on it and say that the risk of harm, right, doesn't equate to the length of time, right?
I think, yeah, we can do whatever we want. And I think that's one of the issues. I agree 100%. We can talk about that, show that. Are there any thoughts from anybody else regarding, excuse me, just the data sets that Mr. Vogel put together? I mean, I just find it really helpful just to look at that and be reminded. Anybody else? Well, let's sort of take that as our opening lens of like, these laws have a disparate impact on certain communities, and let's think about ways where if that's a problem, let's address it. Mr. Vogel, would you be willing to share just the document that we had kind of gone over? I had one other idea just when we were brainstorming a couple weeks ago. I don't know, when we got done, I had another idea that I wanted to share, just to sort of throw in the proverbial hopper on that. So, and this is at the top. So this was just my other addition, and the idea was, and it overlaps a lot with other ideas, but that where an individual's got a juvenile case, it's remained within juvenile court. It's not the more serious cases, no EJJ cases, and no cases where the person's tried as an adult. And that's inarticulately written because the EJJ cases are in juvenile court, but that those juvenile cases, regardless of what the offense is, that person has a 5-year disqualification. And obviously, if that juvenile reoffends in those 5 years, and it would be 5 years after release from supervision. So if an individual reoffends in those 5 years, they're going to be disqualified based on that subsequent incident, not the juvenile one. And the idea is that this is consistent with just a person maturing, consistent with brain science, which would be a reduction of risk of harm. The 5 years sort of comes from the Adam Walsh Act. And that's why it is, I would admit, a little bit arbitrary, but that's where the 5 years comes from. And I just included an example in 2003, 15-year-old, he's adjudicated delinquent for attempted burglary at a closed convenience store, completes the term of his obligations in January of 2015. When he's 17, there's nothing subsequent to that. He applies for a job as a PCA in January of 2022. He is no longer disqualified because more than 5 years has passed, and he has no subsequent disqualifying offenses. So that's just a thought I had. It was somewhat bridging the gap between we shouldn't use just any juvenile offenses to the current structure of permanent 15, 10, and 5. If please, at this point, feel free to share anything positive and certainly negative. We want to make sure that we are pushing each other on that regarding that as an idea. But again, it was just an idea that I had.
I embrace it wholeheartedly. It's really consistent with everything I have learned and know and think, and I really like it.
Great. Thank you, Judge. Ms. Dawson.
I would also agree with that. I think it definitely makes sense. And I definitely like your point about how if the juvenile reoffends, they're going to have the DQ based on the other conduct. So it's really where the actual offense is essentially commensurate with what is happening, not just sort of this blanket. We can't have this sort of foreshadowing of what somebody might do versus what has actually happened. So I definitely support it. And I think, especially for the juvenile, just your straight delinquencies, I definitely think that makes sense. And I also think it's consistent with the Adam Walsh, which really only actually looks at convictions and not even juvenile records anyway. So I think that's consistent. It's even more restrictive than Adam Walsh.
Right. Yeah. And I think that was because I think there is some desire to have some of the more serious juvenile matters have a disqualification period. We might just have to deal with that. Thank you, Ms. Dawson. Mr. Irvin?
I also support this. I like the way you've constructed this. I think the fact that a juvenile right now can have a permanent or a 15-year disqualification is overly restrictive. It doesn't take into account the maturation that should happen over the years since their crime into growing into adulthood. The fact that you have a hook there, that if they reoffend, they'll be judged on that offense, is certainly a safety net for somebody that might think this is too lenient. And it also, it sets something much more reasonable with a 5-year period than a 7, 10, 15 or permanent disqualification for something somebody does as a child. So I support this. I like the way it's constructed, and I like the way you have the language in there about reoffending.
Thanks, Mr. Irvin. Ms. Kaiser?
I agree with all the comments that have been made. One question or maybe back is, what's the thinking behind kind of that starting that 5-year period from the date of release from supervision versus maybe date of offense? Because I know that that's come up when we're talking about, certainly in the adult world, date of conviction versus date of offense. And, there's delays at times with courts. So just wondering if there's some thinking behind date of release from supervision.
I can honestly say no, there is no thinking behind it. I think the idea was to make it honestly maybe more palatable to people that are worried about subsequent convictions, that during a time of supervision, maybe you're not, the training wheels are still on, so to speak. But, I think that's a really good point and a really good thing to kind of flesh out with this. I don't think when I was putting it together, really figured that out. Thank you so much, Ms. Kaiser. Mr. Page.
Thank you, Chair Geffen, and apologize for being late this morning or this afternoon. I'm just curious, and this is my lack of experience in this area, but looking at some of the crimes, are there circumstances, for example, when, a juvenile might be charged with being a felon in possession of a firearm, or arson in the second degree, or false imprisonment, or even manslaughter of an unborn child, where in any of those cases where they would not be getting an EJJ jurisdiction or being tried as an adult. And it's just a question of curiosity and almost a political one, as those catch the eye of people and say, why are they on the list? And I just think there would need to be a response.
And I would ask certainly others to weigh in on this. I know Ms. Dawson and Judge Kulik have more experience probably than I do. The idea was to write something up that excluded those EJJ cases and those charged as adults, because those are going to be the more serious offenses, and trying to look at the group that are younger and not generally as serious. But that was the idea. But I think it's a really good point, Mr. Page. Judge Coolidge, do you have any thoughts on that, separate from your hand being raised? Or
Yeah, well, I want to go back to offense date versus supervision date. We can have our supervision under the regular juvenile court is until age 19. So it doesn't just cut off at 18, it does go till 19. That means a 14-year-old can already be supervised for 5 years. And if the supervision is done at 19, then you go another 5 years, and there's a potential to double that disqualification time. I'm all about the offense because it's really the behavior we're looking at and the age and maturation. So I get the supervision, but when we are requiring, in order to regain the ability to be qualified or not disqualified, that you have to be free of criminal behavior for a certain amount of years, whether that's being supervised or not being supervised. I'm okay either way. There's something to be said for people who can stay law-abiding without supervision, and those who need supervision. But I can't emphasize enough that, especially in this day and age, and it's going to be more about adults, but COVID has really knocked things out of whack. Today I was doing it was adult misdemeanors, but man, some of them are 3 years old. And, if we don't use offense date, it's nobody's fault that these just sat. And again, if we can get a kid who's already been supervised for years and off supervision and has to go years more, might be 25 years old or 24. And finally now, after 10 years of disqualification, can maybe drop that disqualification. So that was one of the things. And I forget what the other matter was. Anyway, enough from me. I'll put my hand down.
Thanks so much, Judge. Ms. Dawson.
Thank you. I think I would echo kind of what's been asked about using the actual offense date, because then you're monitoring the actual conduct versus something that's actually outside of people's control. So I definitely like that idea. And to Max's question, I guess I don't know that I have specifically seen some of those charges, but I think we can probably all, juveniles do sometimes the craziest things. So to say some of those charges don't happen, I'm sure they do. And whether they be EJJ or regular, that's hard to know. But I guess my comment would, and I don't say this lightly for sure, but it's hard to, I guess, anticipate every possible circumstance that may happen. And I think at least I would support looking at this as a whole, even if we just look at what happened in Wisconsin and all of that case that's going on right now. We can't anticipate what may happen, but we can simply look at sort of general, there's at times going to be an outlier. And I think serving the majority of the population is what makes more sense.
And piggybacking on that, Ms. Dawson, I think one of the challenges here is to create or at least recommend a change that isn't so onerous on DHS to apply. The idea of, and it always feels arbitrary, 5 years, 7 years, because not everybody's the same after 5 years or 7 years. Even the science of the brain sciences, people are different. We're not monolithic that way. So there is this sort of arbitrary nature to it. But this is one of those things that we at least have that kind of bright line. And like Ms. Dawson said, it's intended for the vast majority, but there will be some outliers. I just can't ever imagine there won't. Ms. Dawson, under the Adam Walsh Act, did they use conviction date or supervision date?
I thought it was from the date of the offense. Will, do you?
Ms. Dawson, let me look into that quickly. It'd only be applicable for the 5-year disqualifications, because most of them are permanent anyway.
Yeah, and because just kind of by way of update, in the remedies group, we were looking at the permanent list and really comparing that to the Adam Walsh. And our next group is planning to look at if there's going to be recommendations to remove some of the offenses from the permanent list. To
Yeah,
sort of.
not my intent to throw you under the bus and have you but you are our Adam Walsh expert. But I think the goal would be just to have some consistency. And that's why we ended up on 5 years.
So it does say a felony was committed. It looks like it's the date that it was committed. I'm looking back at some of my notes here.
Yeah, I'm seeing the text of the statute as well.
It appears to look at the date it was committed, that the offense was committed.
So what if you got away with it for 5 years?
Yeah, even if you got away with it, apparently for 5 years, it's the
Okay.
date that it's, but it does look specifically at cases where there's a conviction.
Okay. Well, it's certainly something we can kind of add to this. I just wanted to throw it out there. Mr. Page, do you have a comment?
Well, yeah, I was going to say, the statute of limitations might be informative for deciding whether we use the date of offense and if that needs to just be a factor, because sometimes you don't, and maybe those cases are outliers where you don't get charges filed for a year or two. But so maybe it's from the date of charging as another example, but in terms of brainstorming. My other question was going to be if it's worth contemplating whether there should be a reduction in the amount of time if this juvenile admits to the delinquent act, or if there's a trial that comes of it. And I wouldn't want to build in necessarily a mechanism that forces people to, or coerces or suggests that people should admit to a delinquent act, but that may be an admission, may be evidence of acknowledging that wrongdoing and that kind of thing. And I wonder if there is a way to build in a reduced time period, because in the example it just says they are adjudicated delinquent. It doesn't quite tell us how we got there, and maybe that goes down a road that we don't really want to. But
my only concern with writing it was to keep it clean and easy to apply. But we can get it as messy as we want. Yeah, Ms. Dawson.
Well, and I think just piggybacking on that, trying to keep it as clean as possible. I can definitely appreciate Mr. Page's comment about sometimes charges do not come out right away. However, I guess I'd be a little concerned because if we also have the preponderance of the evidence standard, so there may never be charges, which I understand right now under DHS, they're really only looking at cases where there's been a charge for preponderance of the evidence, but that's simply a current policy. That's not actually law. And so which is something the remedies group is looking at, but I just trying to keep it simple and figuring that out. If it's the date of the offense, the date that's charged, which would actually simply do away with any POEs where there's no charge. The date of adjudication, again, I guess I see the concern with that could be years down the road.
Now that all makes a lot of sense. Judge Kulik, please.
Well, there are so many intermediate dates. If we're really looking at this, the science-based brain development and maturation of a juvenile, then it should be behavior-based. And that's why I think if we stick to something as simple as the date of offense, again, if the behavior changes and is no longer criminal, that's what we're caring about, because there is an offense date, there's a charging date, there's a trial date, there's an adjudication date. And how about we just, as I think it's going to be easiest for everyone to understand offense, and it's really tied directly to the behavior that we are concerned about. That's our big concern, not when they got adjudicated, but when they did that criminal behavior.
One of the things that was always, and this goes to the adults too, is it ends up really kind of punishing people that use and their constitutional right to take something to trial. It delays it. Yeah, I like that a lot. Miss Evans.
And I would have agreed with you guys until Max spoke at the last whatever committee it was. I think it was remedies committee. And he talked about the foster care stuff, about they had to pick different dates for different stuff because you guys talk about date of conviction, but if a kid ends up doing a little bit of time and 3 years or 5 years is part of that time that he does, then he gets out of jail and that's all of that time. And especially if some of this rolls over into adult stuff. And so I think having someone with the training wheels off, really proving that their behavior has changed and it isn't under the supervision of somebody, is going to be important to the folks that are going to be looking at this. And so I think, just as between conviction date and 5 years after release of supervision is that, date of offense and 5 years after release of supervision, kind of in the middle of that is conviction date, date of conviction. And so just stuff for us to be thinking about.
Yeah, I agree. I think there are going to be some people that don't like using the offense date if for exactly that situation. I don't know. That was just an idea. It's going to get added to the list. We will probably have some discussion about it coming up in the next full board meeting. Actually, Mr. Vogel, can we go back to that document? I had just a couple other, we can talk about whatever we want, but in case we didn't have any things to talk about, I did just have some things that I was thinking about specifically for juveniles. Should under our, and this sort of, we're just going to forget what we were just talking about with the last idea. But the question I had was, should lower level offenses, the misdemeanor, gross misdemeanors, be a basis for disqualification for juveniles? And just wondering, should the law be more focused on more serious offenses and not what are misdemeanor juvenile adjudications? And I guess what I'm really saying there is my idea would be, it could be an idea that we just, whatever the new structure is, misdemeanors and gross misdemeanors aren't a part of this, and that we're only really looking at the felony cases. Good idea, bad idea? Ms. Dawson.
And actually more of a question, is this group, at some point, are we going to be looking at whether we're going to maybe remove some of the offenses from the structure altogether for juveniles and adults?
Yes.
Okay.
So what I sort of envision what we're doing now is really, and it's going to overlap. Ms. Evans and I have talked about this, this is just going to be for juveniles. We might end up going through really similar discussions for adults, but since juveniles are different, juvenile adjudications aren't convictions, to at least think of them and have some discussions about them separately. But we will revisit, I would imagine, the same questions. As you can see in this document, we look at the felonies, and those aren't just juveniles. But, what do we think about those for juveniles? And do we think the same for adults? And then maybe at some point, we're going to do a little comparison. Does that make sense, Ms. Dawson?
Yeah, it does. I wanted to, so that it doesn't get confusing, and make sure, I guess if we are doing that differently, then that's fine, and separately, I just, for clarity's sake.
Yeah. Was there a time that these dropped off their record once they completed probation?
When you say drop off their record, what do you mean by that? Like it's no longer something anyone can find?
So yeah, like juvenile adjudication, isn't that an adjudication? Isn't that supposed to disappear or drop down?
Yes.
Or just by definition, isn't that
Well, through expungement and Judge Kulik's wanting to, Max, we'll get to you in just a sec. Yeah, Judge, do you have a thought on that?
Well, in theory, juvenile files are closed at the county level, at the court level by county, but the BCA always keeps them. And when you are signing releases of information because you want to apply to college or rent an apartment or apply for a job, and you sign those releases of information, all of that stuff can be revealed by the Bureau of Criminal Apprehension anyway. So it takes an expungement, but most kids don't know that and don't get anything expunged, even if they've had their nose clean for 10 years, including my own kid.
Yeah, I mean, I think there's a lot of misunderstanding, Ms. Evans, in the entire community about what's a record. People are often told, it got dismissed, but well, yeah, your court supervision got dismissed, but it's still available. It might be publicly available, and it might be available to certainly the Department of Human Services and Department of Health, excuse me, and others. Yeah, Mr. Page. My apologies, but please.
Thank you, Mr. Chair. I don't have a huge problem with all misdemeanors being, misdemeanors just being a category that we don't consider for disqualification. There are a few exceptions that the legislature has called targeted misdemeanors that are slightly more serious and just, I would say, interference with privacy, where you're installing like a video camera in someone's shower or something, could be something that would at least want to be looked at. Or, driving while impaired is a targeted misdemeanor, and for an adult, that is, that is the engaging of one legal behavior, drinking, and then illegal behavior, drinking while driving. But for a juvenile, that would be a couple of illegal behaviors piled on top of one another that may want to be considered. Some of those are like harassment, restraining order, domestic abuse, no contact order, stuff that probably isn't as common. But if I think that category under 299C.10 subdivision 1E would be at least worth giving a second look at.
Okay.
Yeah. Those are the same things Kelly said too. Representative Mueller. That's exactly what Representative Mueller said.
Is driving under the influence a disqualified offense under 245C?
I'm not sure that it necessarily is, Mr. Chair. I just know that it is a targeted, your initial offenses, I think, are misdemeanors. And to the extent that I just think if we're doing a blanket, not considering misdemeanors, that we should look at each of those individually or as a group.
I think the targeted ones we'd want to look through. I don't believe that a misdemeanor DUI, DWI is a disqualifying offense. But we would want to look at all of the targeted ones and figure that out. What are other people's thoughts on an idea of, if we were talking about misdemeanors, again, separate from adults, what would be the downfall of having some of these gross misdemeanors not disqualifying? Do we think there's a significant safety issue?
One other issue I'd raise on misdemeanors, I guess, Mr. Chair, is not any single misdemeanor necessarily, but sometimes not. There are cases for juveniles where they rack up, dozens of misdemeanors, and I wonder if there wouldn't even be, some consideration for someone with 15 misdemeanors or something that might establish a pattern of behavior that would at least raise a concern. That would be something I think that would be worth considering. I'm not necessarily raising that as it should be a disqualifier.
I get what you're saying, but just for those sort of chronic low level offenders having something in the, okay.
Yeah, like a chronic, theft. I mean, like chronic theft, misdemeanor theft would be, I think, something that an employer would really like to know about, even if, on an individual basis, that was not an issue.
Yeah. I mean, I think what's interesting about it is if you want to go work at Target, they don't get to know about those thefts because they're juvenile records and they're lower levels. So employers don't get access to that because of their juvenile records.
But
I mean,
sorry.
No,
Sorry.
please.
At what point, Max, after someone, even if they've committed 20 misdemeanors, at what point that someone has not committed a crime, do they get to just not have committed a crime anymore? And that's the point about, like, I was talking to a couple people about this, and it's like, we have this 15-year and 10-year and 7-year. And for the most part, other than these, what did you call them? Interference with privacy, harassment, and domestic. What did you call those types of misdemeanors?
The targeted misdemeanors.
Targeted. Other than these targeted misdemeanors, the only real difference between those 15, 10, and 7 is like how much you stole, how much drugs you had. Like, it's about quantity, right? And I feel like as a society and as people, like, I don't care if you stole my bike or my car. I don't want you in my backyard stealing stuff, right? And so for me, I just care how long it's been since you've participated in this immoral activity, right? Just stop stealing. And so, like, for me, I don't care about the time frames that we have. I just care about how long it's been since you've participated in this behavior. And so for me, I feel like we can get away from these time frames and just have a length of time, not for juveniles specifically, but for all of this, that somebody's been free from criminal behavior, and then say, okay, I think we're safe to give this person an opportunity based on the fact that research shows that once somebody's 5 years free from criminal behavior, that chances diminish significantly that they're going to commit a crime again. And so, like, and that other than these targeted behaviors that are a little bit different and have some psychological stuff that's involved with them, minus the driving while impaired, that one's different. But and so, yeah, I say that.
Judge, I had a question for Judge Kulik. Judge Kulik, do you see those sort of chronic, low-level juvenile cases cycling through? Is that exist in great numbers in your experience?
Nope, can't say that it does, really. And for one thing, juveniles are going to be out of the system, so chronic. But I haven't. And I've only been on the bench for 6 years, but I've seen a lot, and I just don't see the chronic things that I see with kids are really related to trauma behavior. So if a kid gets busted shoplifting, that's usually a one and done. It's the trauma-based behaviors that keep coming and coming and coming. And those are frankly more serious. Those are, assaulting school officials, for instance.
Got it. Okay. And then I kind of had, this question is going to be presented as others have identified throughout, will be how long disqualification periods should be. And we're going to have a lot of suggestions moving forward. But I want to just sort of open up a discussion about, should juveniles have 15-year disqualification periods for felonies in general? And then, are there ones specifically that we think are more serious? When I looked at the list of felonies and I put them below, some of them I don't see a lot with juveniles wrongfully obtaining public assistance, federal SNAP fraud, just because they're kids and rarely do they have participation in that. But just wondering what people think specifically to juveniles about the 15-year disqualification period. Too short, too long, just right?
Mr. Chair, I would say that I think that 15 years feels like a long time for a juvenile, just as a general matter. There may be some of the more serious ones where it would be worth considering, but you know, I think one thing that we've all agreed on and that the research says is that the brain development matters a lot for this, and 15 years just exceeds the development that would occur over that period of time, and that it should more closely match it should be something much shorter.
Thank you so much. And that makes sense to me too. And the idea too, that for any of this to matter, the juvenile must have a period where they're not reoffending, because that's going to re-trigger. And if they're not showing that maturity and brain development, then it doesn't even matter, because they're dinged up on the subsequent disqualification. Anybody else have any thoughts specifically on that, on the 15-year, or do we all agree that 15 years seems too long? And I want to make sure that we are open to people who don't believe that, because I'm sure some people think 15 years makes sense, especially when we're talking about protecting vulnerable individuals.
I think it's too long.
Okay. Will, could you scroll up a little bit just so we get a better look at some of those? I'm sorry, scroll down, my apologies. Just to some of those offenses. And, you know, some of them to me, like possession of shoplifting gear, you know, I don't really know what that means, because it just seems like shoplifting gear is fingers, but I've never been involved in a shoplifting gear case. But like that one seems absurd to me. But are there ones in this list that people feel like, hey, this is a really serious thing and it should be looked at? Because obviously the difference between possession of shoplifting gear and machine guns and short-barreled shotguns is different, as is, you know, assault of an unborn child in the first degree. Those seem really different. Ms. Evans.
Well, I can just point out the ones we're going to get some pushback on, whether I agree or don't agree with them. Is going to be, yep, are going to be 60924 simple robbery down to 20. Oh, quit moving around. 609 to 68 injury and death of an unborn child, potentially even coercion and attempt to coerce. Like those are ones. And then, you know, aggravated, even like the tampering with a witness stuff, like those are the ones where, you know, we're going to get pushback from folks, because they're people crimes, right? You're you know, and yeah, it's people stuff.
And just questioning that, Ms. Evans, do you think the pushback is just in general, or do you think it's more specifically for juveniles?
No, it's in general. It's in general. Like,
okay.
Simple robbery, you're forcefully taking someone's belongings and someone's in fear for their life, and you know, that carjacking and taking someone's purse and false imprisonment. That's you know, robbing a drug dealer and taping them up, and like those are, I mean, that's serious stuff. And you know, when you're talking about a juvenile, that could be a 16 or 17-year-old juvenile, and you know, a lot of times there's weapons involved, and so like the pushback is going to be substantial. I can tell you that right now, because I know the folks we're talking about. And so, and again, with manslaughter of an unborn child, you're talking about a domestic assault or whatever, and a pregnant woman gets kicked in the belly or thrown down a flight of stairs. Like I've read these police reports in the work that we do in our admissions department. And, you know, these incidents are serious. And so, you know, those are going to be ones where I feel like, you having, yep, we're going to have discussions about these, I feel like, with some folks.
Sorry, my dog objected to that comment,
Yep.
Gina. I don't know if you heard.
It's okay. I'm objectionable. That's part of
I mean, I think one of the things I always think about, if we're separating the juvenile, is the existence of the EJJ and individuals being charged as adults, and separating that and trying to figure it out. But it does make sense. And I know that Ms. Evans and others are working on kind of looking at this group of offenses and breaking them down from personal to property and so on. And
how often do these even not get charged? That's what I would like to know. How often do these, like in the courts, not get charged as EJJ?
Does anybody have, I mean, you're talking about the more serious person felony cases.
Yeah.
I mean, I would welcome anybody who has more experience than I do. Judge Kulik, Ms. Dawson.
I've only EJJ'd one kid. The rest have stayed in, and there was an indictment of a kid who was 17 and 11 months. So he got tried as an adult. That was second-degree manslaughter, and the 14-year-old EJJ. The rest of the juveniles for 6 years have stayed in the juvenile system. So that's all I got. And I'd be fascinated by statewide statistics about how often EJJ gets used and for what crimes.
That's a really, really interesting thought, that we need some more statistics and data, I should say, on some of the EJJ and those charged as adults and for what. I mean, my understanding, and of course, Ms. Dawson didn't respond because she had to leave at 45 after, that a lot of these more serious offenses, especially if the person's older, are all going through those separate processes because they're so serious. But it seems that no matter what we do, we want to make sure we back that up with data. So I get what you're saying 100%, Ms. Evans, and I think we need to be aware that there's going to be pushback on that, because if we're talking about safety of vulnerable populations, people with significant crimes against people might, impact that safety of that vulnerable group. We are at our hour, and I want to open it up to anybody else. We can close out this document, though, Mr. Vogel, and hopefully all of you have it. But are there any other comments, thoughts that people would like to share before we adjourn?
I just have, Will, can we email Josh and see if Sarah over at the Legal Rights Center can maybe get that EJJ data? I think they maybe have it, because they do a lot of work around that juvenile justice stuff.
Thanks for the suggestion, Ms. Evans. I'll look into it.
Thank you.
And if they don't have it, let me know, Mr. Vogel, because I think that's available at some other places that we can get it. But I think Josh probably is a great starting point.
Yeah, Sarah and Malika are on a juvenile justice coalition, and I know that it's something we worked on this last year, some of that stuff, and so I think that they have it.
Great. Unless anybody else has something, we can adjourn for the day. We did not formally. We started the meeting, but we didn't have quorum. So do I need to do anything else, Mr. Vogel, to end our discussion today?
No, Mr. Chair, you can just declare the meeting adjourned.
Okay, meeting adjourned, and thank you all so much, and we'll see you all soon. This I thought was really productive and helpful.
Great meeting.
Thank you, Mr. Chair.
Appreciate you all.